How much detail is needed for my will? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. Today we're going to talk about a really common misconception that clients have when they first come to meet with me. And that misconception is simply that they need to list out all of their assets in their will. So the first thing we're going to look at is, what does it take to make a valid will? And the reason we're going to look at it is you're going to see that list of assets is not actually required. First thing you have to do is have that will be in writing. Number 2, you have to sign it. Number 3, we want to have at least 2 witnesses. That's all that's required. So that's why a lot of people think they can just make their will at home. They can just write it up and sign it and be done with it. But one of the most common pebbles I see people trip over is they forget to have those 2 witnesses there to witness their signature on the will. And without that, your will may not actually be valid. But let's go past the basics and look at how much detail do we really need to put into a will. If you're working with an attorney, we're going to have various forms and various provisions that we use for our estate planning documents. And we do this because we want to make sure we have all the different scenarios covered. We want to make sure we're creating a true plan for you in your future. But you may be asking, why don't I need to list all of my assets in my will? So, I want to make sure these assets go to different places. I want to make sure the right people have them. And the reason you don't put all of the assets listed into your will is that you would create a problem every time you change an asset. Let's say you had bank accounts listed and you move from Citibank to Chase. Let's say you have your house listed and you move from one address to another. Let's say you had a car listed and you buy a new car and sell your old one. You'd have to update your will every time you change your assets, whether it's changing to different banks, selling an asset, or changing title to it. So that's why we don't actually put a list of assets into our will. The other reason we don't put that list in there is because some of those assets aren't actually going to be distributed under your will. So when we talk about things like retirement accounts, they often have beneficiary designations. And with that beneficiary designation, that asset will pass to whoever you designate as the beneficiary, as opposed to going into your estate and being distributed under your will. That's one of those estate planning tactics you want to make sure that you're taking full advantage of. We want to keep that number of assets in your will as low as possible so we don't run into any estate tax considerations. Perhaps you've got a house and you use a transfer and death designation, meaning that when you die, somebody else automatically inherits that property. It's like a beneficiary for your property. Well, if you've got that, then that house shouldn't be in your will as well. And in Minnesota, you can even do a transfer and death designation for a motor vehicle. So you can actually take title to a car and have it automatically transferred to somebody else upon your death. Once again, that car would not be part of your will. So that's the main reason we're not going to list all of your assets under your will, because there can be a lot of different places where those assets aren't even going to be considered as part of your estate. And if you put them in the will, what you're doing is creating a bit of confusion and a big headache for your executor or personal representative who has to sort all this out. So of course, if you don't need all that detail in the will, why would people even ask the question? Why is this something they think of? And the answer is because there are 2 situations that you may run into that you do need to put in the detail. The first one is if you're using specific bequests. The second one is if you're creating a trust. So when we're looking at specific bequests, this is usually up at the front of your will. It's a provision that says, my 1962 Corvette goes to my cousin Jimmy. My stamp collection goes to my grandson. My mother's fine china goes to my brother. These are all specific things, specific items that we want to have transferred to somebody under the will. When we have assets like that, identifiable assets that we want to transfer, in that case, we want that detail in the will. It's not just my checking account goes to so-and-so or the money over here goes to so-and-so. You can also have a specific bequest that is for money. You can say $5,000 goes to my church, $10,000 goes to a charitable organization I'm interested in supporting. Those are also specific bequests that we can work with. So when we're dealing with specific bequests, we do want that kind of detail in your will. Second place where we want that detail is if we have a trust. So if we're creating a trust, what we're looking at is moving title to certain assets into the trust so that the trust actually owns those assets going forward. So I recently dealt with a client who wants to move their house to a trust. They actually created a trust about 15 years ago. However, their old attorney never actually transferred the property into the trust. So even though they have a trust and they have a whole system built out for it, the asset isn't actually owned by the trust. So if we're going to be dealing with assets that we want to put into the trust, This is where the detail is important, not to have it in your will, but to have the details so we get the title correct, so that we know that the title to that asset has been moved into the trust, and then the trust will control what happens to that asset if something happens to you or your spouse, or the asset has to be distributed. So those are going to be the two main areas that I see where you're going to have to make sure you do have specific details in your estate planning documents. Now, as I said before, like when it comes to a will, a lot of people do try to do it themselves. Maybe they've used an online form, and that's where a lot of people will trip up, frankly, because they put all of their assets into the online form, and they've got retirement accounts in there with benefits. They have other assets that have beneficiary designations, and then the will that's spit out has all these assets that don't belong in the will. Of course, other people just write their will on a piece of paper and they sign it and then forget to get witnesses. So the better way to handle all this is work with a professional. Talk to your financial advisor. Make sure you understand what assets would be part of your estate and what assets will be distributed by a beneficiary designation. And then that financial advisor will likely tell you, come to meet with an attorney. Come to my office, go meet with your attorney to go over your estate plan and where you want these assets to go. If you're ready to get started and you're looking to take those next steps, you can go to my website, andrewmayers.com. There's a red Schedule a Legal Strategy Session button on the front page. Click that and you'll be taken to my personal calendar. We'll set up a 15 or 20-minute phone call where we can discuss where you are in this estate planning process and what those best next steps are. Don't think that you have to put all of the details about all of the assets you own in your will. That's actually one of the most common barriers people have to estate planning, is they think, well, I don't have a full list of assets, so I can't go meet with that attorney to get my estate plan set up. You don't need to, so go meet with a professional and make sure you get your estate plan in place so that you've got the right assets in the right place.